Good morning. Thank you so much for the presentation. I just had a question for Rebecca. As you previously mentioned that inclusion of secondments means that someone from the UK can be considered a secondee within the DIFC. However, under the new law, a secondee needs a residence visa in order to apply for a secondment card, which needs a valid employment contract between a DIFC entity and this individual. Therefore, wouldn't you say that all the provisions under the new law apply to them as an employee as opposed to a secondee?
This is something we talked about quite a lot actually when we did this. The idea, and Jack, you might want to talk about this a bit more, is that actually the secondment card won't necessarily just apply to those who are already in the UAE with a residence visa. So it potentially can also cover those who are coming from abroad.
That is correct. I mean, we're obviously sitting currently with our registries department that does all of the registrations in the DIFC and hands out the secondment cards, and that will change. So going forward, you would be able to come and apply for access and a secondment card in the DIFC without having a valid UAE employment contract.
Can I ask, Jack, will a secondment card be available to all types of companies, or will it be limited?
Not. I mean, the reason, and the law is not clear on this, and this once again goes back to the follow-on seminar that we will have on more practical issues. We don't want secondment to be your way out of the law applying. And agreeing to some other applicable law. There's still minimum conditions of employment that apply, even if you are here on secondment. But we don't want secondment to be an easy way out. So the DIFC will apply its mind. You will have to come and apply for it in the first place. And if it's a legitimate reason, if you work for a bank or for a law firm, and it's clearly that person comes on a temporary placement, and what the law says, it's basically a 12-month period. We can expand that or extend that. We have the discretion to do so, but we will really look carefully at whether you are trying to keep a person here on terms that are not in line with the employment law, or whether there's a legitimate reason for the secondment. So that comes into play now. I think the other key thing to remember is that if you look at how secondment is now drafted into the law, so if you look at termination periods, if you look at how end of service is being calculated, then any period of secondment will be included into that calculation. There's one more at the back, and then we'll move over to this side.
Yeah, hi. This is again regarding the secondment. Suppose if we employ have a secondment arrangement with the employee, which is currently for the group company, which is onshore company. So how do we treat this as, we treat them as non-DIFC employee. So can we still treat them as non-DIFC employee?
I mean, there's a number of instances. Now, I'll use the very simple example of somebody working in one of the retail outlets as a shift worker that maybe sometimes works here and sometimes works in other outlets onshore. That person, the argument can probably be made that that person is here on a secondment because they're not always here full-time. And that's probably the type of situation that somebody comes after a year and asks for an extension, we will do it. In terms of some of the banks have, say, onshore branches and branches within the DIFC, and that particular individual goes back and forth. Some days that individual is at Imar Square, sometimes that individual is in the DIFC. That is probably a type of situation that if that person, their primary duties are onshore, we will probably look at allowing that as a secondment. But I think where you get into situations where it is clear that this is just a means of not being subject or not wanting to be subject to the DIFC employment law and all of its requirements, we will probably not allow for it in the first place, or if after a year that becomes evident, then we will not renew that secondment.
Okay. And one more question. Is there any, like onshore companies, is there any special court or tribunal to deal with the only employment-related issues in DIFC? I think it's not. So is there any proposal to have those kind of?
Yes, there is. The DIFC courts have a small claims tribunal. Typically, the size of claims related to employment matters fall within the jurisdiction of the small claims tribunal. I think the other important point that we want to make is that when it comes to discrimination claims, those claims will only be heard in the court of first instance. They will not be heard in the small claims tribunal, just because the complexity of the issues involved.
When a person is being terminated or is resigned, sometimes they ask for more period to keep the visa, even if the termination period is over. So is there any way we can hold the payment till they move out of our visa, even after the termination date, even after the notice period, as per law? Or do we have an expressly written agreement between the staff and the employer and the employer?
So there's two issues there. One is to do with the visa cancellation, and under the new law, it's very, very clear. An employer and employee must ensure that the visa is cancelled within 30 days of the termination date. So that removes all the questions. Can we keep their visa open? No. So that's the first answer. Your second question, can you defer payments or what have you? Again, it goes back to Rebecca's point, which is no. You need to pay everything within 14 days. And that obligation to pay everything within 14 days is completely separate from any issues to do with visas.
Okay, thank you.
Just to add to Ben's point, now the law makes provision for fines to be distributed by the DIFC if visas and other immigration infractions and other issues where the employer has fallen foul of the DIFC law, that the DIFC authority has the power to issue fines. So where you have employees that are still pushing back, sometimes understandably for reasons to do with children's schooling or whatever the case may be, unfortunately, from a DIFC perspective, the advice is always going to be, whether it's from Tamimi or Clyde, I imagine, you have to cancel the visa within the 30-day period.
So I think that will put an onus on employers to actually think more about the way in which they're going about the termination and how can they structure it in such a way as to give the employee more time to sort out their affairs.
And it's probably going to lend itself again to having more assessment agreements actually, because at least with assessment agreement you can set out when the visa is going to be cancelled, when the payments are to be made, and as obviously we've already talked about, you can also waive claims as long as it's a assessment agreement where someone has had the opportunity to get legal advice. So I think we will see more assessment agreements where employees are being given notice to terminate employment.
Okay, so moving on to this side. Okay, one final question for this cohort, and then we'll move on to that side.
I hope it's a good one. You've been waiting long enough.
Yeah, and I tried to skip you twice.
Thank you. Will there be any limitations or obstacles or issues to be aware of with respect to employees over the age of 60, either with respect to the law or with respect to granting of employment visas?
Yeah, I mean, I think that absolutely now, as was mentioned in the discrimination piece, that there will be a potential claim for somebody who's over the age of 60 who is treated in a particular way, as compared to somebody who's a different and younger age, to potentially to frame a discrimination claim. And simply the argument that it's going to be difficult to get a residency visa wouldn't apply, in the sense that, yes, there can be challenges as people get older in terms of obtaining a residency visa, but that wouldn't be a sufficient excuse or explanation for an employee not to continue to employ somebody who's over age 60 on the basis of that alone.
Just playing devil's advocate to that, I guess if you did terminate, I'm just sort of thinking ahead, if you did have an employee who wasn't able to obtain a visa and perhaps due to their due to their age, and you terminated them because of that reason, because you can't get them a visa, and they then brought an age discrimination claim against the company. I guess what you could argue on behalf of the company is, well, no, we terminated them. Our reason for termination was a proportionate means of achieving a legitimate aim, and the legitimate aim was to not employ that person in breach of UAE immigration law.
Yeah.
Because you can't.
Yeah.
So there, it's. I mean, it will be a sensitive issue.
Yeah, and the point is, though, but simply to rely upon that, there's been a misconception over the years that you can't get a residency visa for somebody over the age of 60, which is a misconception. You can. It can be that it's subject to additional vetting by the immigration authorities before it's processed, but simply looking at Ben's example and my example, to not try and just rely upon almost like a default retirement age and say we're not employing anybody over age 60 because there's, I'm using that as an example, would be an issue. That would be a policy criterion or practice that was potentially a discriminatory one. Yeah.
Yeah, you definitely have to make the effort to try and get the visa.
Okay, thank you. I mean, it's also a matter of forward-looking as a destination for continued employment, where for the employee, from the employee's point of view as
Perspective, yes.
expectations and
Yeah.
planning, which I
Indeed.
raise as a topic.
Thank you. And moving on to the cohort on this side.
The question is basically, so when we say end of service gratuity and the final payment needs to be done within 14 days, are they 14 working days or 14 calendar days?
It's calendar.
Thank you.
Good morning. Regarding secondment, if it is a law firm and a lawyer is coming from UK or US office, secondment can be for a year or two. Would be a secondment card will be given or visa, or it has to be like a permanent employee visa?
Yeah, to the first part of the question, one of the areas, whether it's trainees coming in on seats or people working on particular mandates, we often see law firms seconding people in, and we don't have any issues with that. And it's probably one of the areas where we will, be far more lenient in terms of providing for a secondment card. So that's the first part. In terms of the second part, is what would be the requirements in order to obtain a secondment card and basically have access to the DIFC and work here. That we will come out with a separate guidance and a handbook, so there will be absolute clarity on how you apply for it. But it's not the current regime where there is still the requirement where you have to show a UAE employment contract.
And just on that, in terms of if you've got someone, because you mentioned 1 or 2 years, and I suppose the point is, if actually you think you've got someone who might be on secondment but ultimately is going to be here for a long period of time, bearing in mind that in most secondment cases the secondment card can only be for a maximum of 12 months. In reality, at some point there won't be a secondment card and someone will become a permanent employee. Now at that point, as we mentioned earlier, all of the entitlements effectively are backdated, so it includes the secondment period. So on that basis, actually I think we will be saying to most of our clients, look, this isn't a way of just trying to dodge the entitlements for a year, because you're going to have to address them anyway if they're going to stay here for longer than the 12 months. So actually the secondment card really is for a genuine secondee rather than just a means of avoiding entitlements for a year.
So let's say if the employee is on a secondment for less than a year and he doesn't have a UAE visa, any type of UAE visa, whether mainland or free zone, so, and he's coming from abroad, what type of visa he should have?
This is obviously something that our registries will have an agreement of sorts with immigration. I mean, they sit in the same room, so they will provide for that. And on the back of a UAE secondment agreement, they will provide that visa.
One more question, please. In relation to employees' commencement with DIFC visas, if a person has an entry visa or a change of status has been done, but still DIFC are not allowing them to enter the office or start their employment until the visa is stamped in the passport. However, it is as per immigration rules and regulations or Ministry of Labour, his employment starts from date of his entry into the country or change of status is done, and he can commence his work for he can come to the office. So why not in the DIFC?
Yeah, I mean, this is, I can't speak for registries. I can only say from a practical perspective, we will try and help. Often people in that interim period, get a visitation. There's a visit card that you can apply for. There's a number of ways to deal with people being here, having entered the country and now waiting for the stamp to be placed in their into their passports. Practically, there are ways and means that registries are trying to help you prior to the person actually getting the visa, because without that, you won't be able to get the access card. That's just another requirement from immigration.
Excuse me? Excuse me?
But it's not illegal, right, to start the work?
No, not as far as I'm aware, not from a federal perspective.
Thanks a lot. Thank you.
Excuse me? My question is regarding being treated equally. What if there's an organization, let's say, which has in its employment contracts for its employees where some have certain benefits while others don't? So does that count, like of being not being treated equally?
Yeah, it's a fine balance. I mean, you're not expected to have all of your employees on the same terms and conditions of employment, in the sense that you have people from different backgrounds, people with different expertise, people coming from different jurisdictions. So it's not expected to be one size fits all, and uniformity across the terms and conditions and benefits that all of your staff have. Where the caveat comes in is, obviously we've all read about the equal pay cases in other jurisdictions where you have, for example, typically men being paid more than women in certain roles, and so therefore that is an element that needs to be considered in terms of how your comp and benefits is structured, because it may give rise to a potential claim if you are treating one set or category of employees differently from another. That's completely different from paying people or providing them with terms and conditions which might not be aligned throughout the business. So it's a balancing act. It's one that's going to have to be reviewed on a case-by-case basis for each organisation within this room.
I think the key thing is, I mean, you have to understand, ultimately, an employment contract, there's a one-on-one and what's being negotiated on commercial terms between an employer and an employee, and essentially the laws of supply and demand play a role in terms of what people get paid and what their benefits are. I think, and we're not trying to take away from that. I think what if as a rule in your organization you pay, in the same grade with the same job responsibilities, say men more than you pay women, there may be an issue. So you should look at it from that perspective, rather than one guy being paid more than the other. That would never be essentially be grounds for discrimination.
Hi, I've got two questions. First one, so the new law says that the basic wage should be at least 50% of the total wage. So should that be reflected in the employment contract? And if it's not there yet, should the employment contracts be revised?
So what the law says, that for the purposes of gratuity, it needs to be at least 50%. So please don't all go out and change your employment contracts so that the basic wages are 50%. It's just at least 50%. You have two options. Either you do change, if you are currently providing a basic salary which is less than 50% of total remuneration, you can either change your employment contracts or just wait for termination, and bear in mind, upon termination, when you are calculating gratuity, you will need to do it at a level of 50%.
And my second question is, suppose if an employee takes in excess of the leave that he's entitled to, the deductions, should it be based on the basic wage or the total wage?
It's daily wage. One of the huge improvements of the new law is actually the various definitions of remuneration, basic wage, annual wage, daily wage, for the purposes of calculating maternity pay, holiday pay, public holidays, sick pay. They are all now extremely clear, and they're in the definition section of the new law.
Thank you for the talk this morning. Outside of the non-discrimination, anti-victimization, Part 9 provisions, are there any protections for whistleblowers, anonymous or otherwise?
Yeah, this is something that was discussed early on. There isn't in the DIFC employment law, but there is in the DIFC operating law. So the operating law, which also was enacted not long ago in 2018, has whistleblowing protection, whereby if an individual makes a disclosure which fits within the definition under the operating law, then he or she can be subject to a detriment or dismissal as a result of making a disclosure. So you won't find it in the DIFC employment law, but the one to look up is the DIFC operating law.
Thank you.
Just on that point, the first draft of the employment law that actually went out had the whistleblowing provisions in that employment law, and it was sort of then superseded by the operating law, which sort of cuts across everything in the DIFC in any event. So we took it out of the employment law and actually put it into the operating law, but they still apply.
Thanks for the talk. Just had a quick question about secondment again. We have a group company, and we have one of our executive management that is seconded into DIFC purely for oversight purposes, for directorial duties, etc. But he operates outside of the DIFC from an onshore basis. This is going to be an ongoing secondment. So how long before that individual is then considered a permanent employee? Is there a sort of a number of years that we need to be bearing in mind?
The way the law is written is basically provides for a 12-month period, but it also gives the DIFC authority the discretion to extend that period if good cause is shown. So the example that you've given, and if it's very clear that this is not where the person is sort of primarily performing his or her duties as an employee, then we would be very happy to extend that. But you will have to come and explain that, and it will be an annual renewal. So we will look at it every year to make sure that it is actually a bona fide secondment and not a way of trying to get away from entitlements, etc.
And one of the keys is that the way the law is drafted is whatever an employer and employee may agree in terms of a secondment arrangement is actually a little bit irrelevant. The key is whether the DIFC have issued a secondment card. If the DIFC has not issued a secondment card, it is not a secondment. So it will. The first question we ask clients when there's any sort of calculation of entitlements will be, do they have a DIFC secondment card? No. Well, then they are an employee.
I would like to know whether the employer and employee need to rewrite the contracts as per the recent employment law.
Yeah, it's going to depend how your existing employment contracts are drafted, without wishing to dodge the question. So in most cases, there will be amendments that may be required. We'll use sick pay as an example. It might be that the business is happy to retain the previous sick pay entitlement, and the rest of the contract may otherwise be in compliance with the new law, and it might be that you can continue to use it. It might not, though. So it's going to depend what's in your contract, the way that the clauses are drafted, and whether or not changes need to be made, and whether or not those changes need to be made by way of a new contract or by way of an addendum to the existing contract.
And I don't mean to drum up business, but yes, I would say you will need to have a look at your contract. You'll also need to look at your assessment agreements, and I would also say look at your policies as well. So actually, I think I'm not saying it's a wholesale revision of anything, but certainly there are likely to be things that you will need to amend in all three documents.
And because of the vicarious liability provisions which Rebecca mentioned earlier, I can't see any circumstances why an employer would not have anti-bullying and harassment policies, equal opportunities policies, and because of the operating law, whistleblowing policies. If you don't have them, you won't have any defence to a vicarious liability claim.
Article 14 provides for the terms that an employment contract needs to have. And one of the points is a reference to any applicable policies and procedures, including any code of conduct and where they can be assessed. So if an employment contract does provide, for example, you will be entitled to medical cover as per the company policy, but the contract doesn't actually provide where that policy is, do we need to amend the contract, or does it fall as an administrative change and we send an email to all employees saying this is where you can find the medical policy, for example?
Yeah, I mean, that's the purpose of having a contract and then separately policies. And as long as it's clear within the policy guidance that the policies do not have contractual status, then changing the terms of your medical insurance provider would be a change that would not require you to amend your employment contract. You would be simply able to make a policy change and communicate that to the workforce.
Actually, where it is to be found. Because the employment contract says you're entitled to medical cover as per the company policy.
Yes.
The new law says that the contract has to provide where the policy is to be found. So the question is, do we need to amend the employment contract to say that you're entitled to medical cover as per the company policy and the policy can be found?
Can be found on our intranet policy, or intranet site or whatever.
Or can we just send them an email making them aware of the new law and saying this is where you can find it and that would be sufficient to cover this?
I would suggest that the latter would be sufficient. I think it's highly unlikely. It would be a pretty draconian step by the DIFC to issue a $2,000 fine for taking that approach.
It is an administrative change.
Thank you.
A lot of the law is also is a sort of a guide for best practice. If you don't 100% follow it, you know, there's probably not going to be some big court case that arises out of it. But technically, if you want to comply, you need to say how people can access those policies.
Thank you.
Excuse me, I have a question. Sorry.
Hello?
Here.
Okay, just go ahead.
Sorry, can I ask one question? Because I was all the way in the back. Regarding the limitation period, the new one is 6 months. What was it previously? Was it under the court law and it was 6 years? Here, sorry.
Sorry, I was so busy trying to find you, I wasn't listening to the question. Could you just say it again?
The limitation period, it's 6 months now. What was it under the previous law?
So under the current employment law, the old one, didn't have limitation periods in it at all. So instead you looked elsewhere, and it was 6 years for statutory claims, 6 years for contractual claims. Yeah. But I guess, again, the problem that you have is it wasn't in the law. It wasn't all that certain for people. No one really knew. The idea now of a 6-month limitation period is, one, everyone now knows what it is, and also I think it means there is certainty for both employer and employee actually on this, because the problem with a longer limitation period is that if actually someone has a genuine claim, over a period of time, people are going to forget, you know, so if you need witnesses in court, no one's going to remember 6 years down the line. So at least now it means that there is some requirement for people to get on with it and bring a claim, because I think without that limitation period, actually you may have one party who does know what the claim is and the other party who can't remember, and so that addresses that imbalance.
Was it also to kind of reduce the time frame for employees to claim delayed payment after termination for the article, I think 18 or?
I mean, that is I suppose that is a factor as well. So yes, I mean, essentially you've got 6 months in which to bring your claim.
Yeah. Once again, it's an issue of legal certainty. You don't want to terminate relationships and have them sit and wait there for 6 years and hoping somebody doesn't bring a claim. And that, from an employment-related perspective, that's what you will see globally. So it's not as we're trying to pin employees down and limit their rights in this regard. That this is actually 6 months is actually a very long time from a global benchmarking perspective.
Yeah, because it's 6 months after termination. So if an issue arises during the employment relationship and you work for the employer for 10 years, and then you can still claim it.
The The only distinction actually around limitation periods is it's with discrimination it's 6 months from the act. So if it's a course of conduct, it would be 6 months from the last discriminatory act. So conceivably, you could have an employee who, during the currency of their employment, still brings a discrimination claim, provided that he or she does so within 6 months of the last act, the last discriminatory act.
Okay, so we're trying to wrap up. There's one question here.
Yeah.
Anybody else with pressing questions?
Yeah, I have two questions. My number one question is we have end of service policies merged with our HR policies. So now end of service is coming due from 1st of January 2020, whereas the new employment law is effective from 29th August 2019. So should we amend our policies before 1st January 2020, or we have to do it this part now and the end of service part later when it will be applicable?
I mean, just from my side, the one key change, the 50% of minimum, well, now you can't take away gratuity. So that's one thing, and that will flow through into dues. You won't see that again. In terms of the 50% requirement of basic wage, that's the minimum that you can apply in terms of the calculation. That will be extrapolated into dues, so that will not change. In terms of you now having the ability to provide for alternatives, which we give now, but we say it shouldn't be less than what is provided for in the law. By the end of August, you will have the details of what we will regard as a qualifying alternative scheme, and that will also be extrapolated into dues.
All right. Okay, my second question is that if some employee feels that he or she is treated unfairly in the company, so what are the avenues available to him or her? Is it only through the court in the DIFC, or there is through the DIFC itself, without endangering his or her job?
Yeah, I mean that's the purpose of having a grievance policy, and ensuring that grievance policy is available, because ideally what you want to do is, of course, avoid any form of litigation or any form of dispute resolution that needs to be managed externally. You want to deal with it in-house, so that's where your grievance process needs to be robust. Outside of that, obviously we talked earlier about mediation. There are other alternative dispute procedures that can be exhausted before parties go to court, whether it's, I mean, the most typical one in an employment context would be mediation. There are plenty of mediators either that can be arranged through the DIFC or independently that can try and resolve a dispute between an employer and an employee if it's not incapable of being resolved internally. And then if all else fails, of course, and the employee still remains dissatisfied, that's when there is recourse, obviously, to the court via the DIFC. Yeah.
Okay, thank you very much, everyone, for attending. I hope it was useful and informative for you guys as it was for us. And once again, thanks to the panel for your time and your effort. Thank you very much.